A lot of people are screaming that the Supreme Court just killed assault weapon bans for good. That is not what happened. But something big did move forward again, and if you own an AR-15, a standard magazine, or you travel with firearms, you need to understand this right now. Quick question before we continue. Are you subscribed? Because updates like this can change what is legal in your state faster than most people realize. Hit that button now, because what I'm about to break down could save you from making a very expensive mistake. Here's what just happened. The biggest thing to understand is this. The Supreme Court has not issued a final ruling that wipes out assault weapon bans across America. Not yet. What actually happened is more complicated, and honestly, that's why so many people are getting this wrong. Back on June 2nd, 2025, the Supreme Court refused to hear two major gun cases. One was Snope versus Brown, which challenged Maryland's ban on certain semi-automatic rifles like the AR-15. The other was Ocean State Tactical versus Rhode Island, which challenged that state's ban on magazines holding more than 10 rounds. The court did not say those bans were constitutional forever. It also did not say the bans were dead. It simply chose not to take those cases at that moment. Now that may sound boring, but it matters a lot. When the Supreme Court denies review, that is not the same as saying, we agree with the lower court. It usually means, we are not deciding this case right now. That's a huge difference. And here's the part nobody's talking about. Those two cases were looked at again and again before the court finally passed on them. That tells you the justices were not ignoring the issue. They were wrestling with it. They knew this question was big. They knew it was not going away. Even more important, several justices practically said, we're coming back to this. Justice Clarence Thomas openly said he would not wait to decide whether the government can ban the most popular rifle in America. Justices Alito and Gorsuch also wanted to hear the challenge. And Justice Brett Kavanaugh said something that really got people's attention. He signaled that gun owners have a strong argument when they say AR-15s are in common use, and he suggested the court would likely deal with that issue soon. That matters because common use is one of the biggest ideas in modern gun cases. In simple terms, if millions of regular law-abiding Americans own a firearm for lawful reasons, the argument is that the government cannot just treat it like some rare military oddity. That is the battle line. But here's the crazy part. Even after the court passed on those 2025 cases, the legal pressure did not stop. It grew. New cases kept coming. That is why people are saying the fight got pushed forward again. Not finished, not won. Pushed forward. Second, let me explain what pushed forward again really means, because this is where headlines start playing games with your emotions. In early 2026, the Supreme Court took several new gun cases and relisted them. That word sounds technical, but here's the simple meaning. The justices looked at the cases and did not immediately deny them or accept them. They held them over for more discussion. That is not a final win. But it is also not nothing. Among those relisted cases were challenges to semi-automatic rifle bans and magazine bans from states like Connecticut, Washington, California, and Illinois area laws. Cases like National Association for Gun Rights versus Lamont and Viramontes versus Cook County put the semi-automatic rifle issue back in front of the justices. Duncan versus Bonta and Gators Custom Guns versus Washington kept the magazine issue alive too. So why does that matter to you? Because it shows the court is still being fed these questions from different states, different federal courts, and different legal angles. Think of it like pressure building inside a pipe. One case may not be the one that bursts it open, but if enough strong cases keep coming, eventually the court may decide it has to settle the issue for the whole country. And this is where it gets interesting. The justices often like to wait for a clean case. They want strong facts. They want the issue clearly framed. They want lower courts to weigh in first. They may even want different appeals courts to disagree before stepping in. So when you hear that a case was relisted, it can mean the court is taking a harder look before making its move. Now, don't make this mistake. A relist is not the same as a ruling. It does not make your banned rifle legal in your state. It does not cancel magazine restrictions. It does not mean your local prosecutor suddenly lost power. It only means the fight is still very alive. Imagine a football game where the referees go under the hood to review a play. The crowd starts yelling. One side celebrates, the other side panics. But the scoreboard has not changed yet. That is where we are right now. If you're finding this helpful, imagine what you'll learn in my next video about the exact words that keep gun owners from talking themselves into trouble during police encounters. Subscribe so you don't miss it. Third, let me break down why this matters in the real world, because legal talk means nothing if it doesn't connect to your life. Right now, if you live in a state with one of these bans, that law is still in force unless a court in your area says otherwise. That means you cannot watch a flashy headline, assume freedom has arrived, and start buying or carrying based on internet rumors. This is what most people get wrong. They hear, the Supreme Court is looking at it again, and they act like the law changed yesterday. No, it didn't. If you live in Maryland, California, Connecticut, New Jersey, or another banned state, your local law still controls what you can buy, possess, transfer, or bring home. And remember, the term assault weapon in these laws usually does not mean machine gun. That confuses a lot of people. In many state laws, it means certain semi-automatic rifles, pistols, or shotguns with listed features, or certain models named by law. The details vary by state, which makes this even more dangerous for regular gun owners trying to stay legal. Here's a hypothetical example to explain this. Let's say you live in a free state and legally own an AR-15 with a standard 30-round magazine. Then you move for work to a state with a ban. You saw a video online saying the Supreme Court pushed the issue forward again, so you assume you're protected. You pack your rifle, cross state lines, and settle into your new place. But the ban in that state is still active. Now, you may have just created a criminal problem for yourself because you believed a headline instead of the actual legal status. That is why this matters. Now, quick legal note, this is educational information, not legal advice. Always consult an attorney for your specific situation. Another example, maybe your state allows your setup, but you travel through a banned state for a match, a hunting trip, or a family visit. Most people think, it's legal where I live, so I'm fine. But the truth is, your home state law does not magically travel with you. State lines can change everything. And let me say one more thing here. Just because several justices sound skeptical of assault weapon bans does not mean the outcome is guaranteed. Courts are not YouTube comment sections. Judges do not rule based on who sounds the loudest. They rule on the case in front of them, under the legal test they choose to apply. That means timing, facts, and which case gets picked all matter. Fourth, here is the part that shocked me when I dug into it deeper. Many people act like the Supreme Court is moving too slow because it does not care. That may not be true at all. It may be moving slowly because it knows the decision could reshape gun law nationwide. Think about how big that is. If the court takes a clean assault weapon case and says bans on commonly owned semi-automatic rifles violate the Second Amendment, that would hit multiple states at once. On the other hand, if the court upholds those bans, that would strengthen those laws and make future challenges much harder. So yes, the stakes are massive. That is also why Justice Kavanaugh's words mattered so much. He did not vote to hear Snope at that time, but he basically waved a flag saying this issue is not settled and may return in the next term or two. That is not a final opinion, but it is a message. Thomas was even more direct. He said he would not wait. Now this is where it gets even more interesting. Lower courts are still fighting over related questions. New Jersey's ban has been a major one to watch. California remains a battleground. Illinois area cases are still alive. Connecticut cases are still alive. In other words, the pipeline is full. The Supreme Court does not need one single case to carry this issue forever. There are multiple vehicles lined up. That also means you should be careful with anyone online who says, this next case is guaranteed to end all bans. Nobody knows that. Not me. Not them. Not even the lawyers bringing the cases. A strong case can still get denied. A weaker case can sometimes get taken. And even when the court agrees to hear a case, a final decision can still take months. Hey, 73% of people watching channels like this are not subscribed. Don't be part of that group. Join the gun owners who want the facts before the panic starts. Click subscribe so you get these updates first. Fifth, let's talk about what you should actually do right now, because this is the part that protects you. First, do not change your behavior based on the words pushed forward. That phrase describes movement in the legal fight, not a final victory. Second, check your own state law, not just national headlines. Third, if you own rifles or magazines that could be restricted, know exactly how your state defines them, not how your buddy defines them, not how social media defines them, how your law defines them. And fourth, if you are waiting for a Supreme Court case to change things, understand the timeline. Even if the court agrees to hear one of these challenges, there would still be briefing, arguments, and then a written decision later. That takes time. A lot of time. Here's what most people miss. The real danger is the space between rumor and reality. That gap is where people get burned. A gun owner hears, the court is about to end the ban. He buys something too early. He posts it online. He transports it the wrong way. Then he learns the hard way that about to is not the same as it happened. So where are we today? We are in a pressure building stage. The court already showed serious internal interest in these cases. Several justices openly signaled concern with bans on commonly owned rifles. New cases were pushed forward for more review. Lower courts are still producing new decisions. And all of that increases the chance that the Supreme Court eventually takes a case and gives a nationwide answer. But we are not at the finish line yet. That means your smartest move is not celebration. It is preparation. Stay informed, stay calm, stay legal, watch the cases, watch your state, and do not let a loud thumbnail make legal choices for you. Laws change fast, court dockets move quietly, and the people who stay ahead are the ones who pay attention before the final ruling drops. Subscribe now, because my next video will break down the exact assault weapon and magazine cases most likely to reach the Supreme Court next, and what each one could mean for you. So here's the bottom line. The Supreme Court has not permanently ended assault weapon bans, but the issue is very much alive, and new cases have pushed the fight forward again in a serious way. That means your rights may expand later, or your state may stay the same for now, but either way, what you do today still has to match the law that exists today. If this helped clear the smoke, subscribe and share this with one gun owner who always falls for the headline before reading the facts. I want this channel to keep regular people informed, calm, and out of trouble. And one final reminder in simple terms. This video is for education only, not personal legal advice. If your freedom depends on a decision, talk to a real attorney in your state.